I really want to thank Anumeha for inviting me for this talk today. It's always, I think I steal opportunities to be associated with Faculty of Law. It has been my alma mater, and it's always a pleasure to go back to that space for any purposes, and especially, back as a faculty. So thank you, Anumeha, for thinking of me, giving me this opportunity, and especially the opportunity of sharing my ideas on this theme. Now, today I'm going to talk about consent and rape law. And what I'm going to talk about today has a real significance for us in the light of the developments that have taken place across the world in the last few years. But my focus today is going to be primarily on the definition of consent that has been inserted in IPC by virtue of 2013 amendments. We all know that an explicit definition of consent is now a part of Section 375 of the Penal Code. This legal move has opened up many interpretive possibilities, which I believe can transform not just the legal discourse and judicial practices, but also the social and cultural understandings of sexuality, particularly heterosexuality and heterosexual desire. In my talk today, I will have a threefold focus. First, I will try to critically look at the definition of consent, focusing on its constitutive elements, particularly in the context of Delhi High Court's decision in Mahmood Falukhi versus State. I'm sure we all have read that decision. It was widely debated, critiqued, and I think it is important for us to constantly keep going back to it because there's a lot in it that needs to be fleshed out if we really have to make sense of how heterosexuality and how heterosexual consensual relationships are to be understood. Secondly, I will argue for a reading of sexual consent beyond liberal individualism and structural determinism. And I would push the argument informed by psychoanalytic accounts that understand sexual desire as well as sexual agency in a far more complex manner. And finally, I would try to discuss the issue of mens rea in rape cases, whether there's mens rea or whether it is a strict liability offense, and situate this discussion vis-a-vis the absence of consent. So, starting with the first part. We all know that sexual consent is one of the most complex sites for criminal law. If we look at the history of sexual consent, as a legal category, it is imbued with colonial stereotypes about sexuality of Indian women. Along with the interventions of Indian women's movement and feminist legal scholars in India, in the aftermath of the infamous Mathura rape case, the definition of consent in heterosexual contact expanded in meaning as well as scope. It was emphasized that consent cannot merely be deduced from fear of death or hurt, that absence of resistance is not indicative of a consent, since passive submission does not amount to consent, and so on and so forth. In the 1983 amendments in IPC, as well as the concomitant amendments that were made in the Indian Evidence Act, some of these questions of sexual power were addressed. But the inquiry about consent continues to be about marks on women's body, making the spoken word suspect, and rendering experience of violation of bodily autonomy irrelevant. And I'm sure if we go back to the work of Elizabeth Kolsky, and more importantly, the study which is done, ethnographic study which is done by Pratiksha Bakshi in the trial courts, all these issues actually become very, very poignantly explicit. Having said that, we need to concede that there are, as far as the discourse around consent is concerned, there have been various progressive pronouncements of the Apex Court, which have established that physical resistance was not the significant factor in determination of consent. In fact, in 2011, Supreme Court categorically said in a decision that the expression without her consent comprehends an act of reason accompanied by deliberation. So we have seen, that in the judicial archive there are important progressive decisions, which have actually tried to delineate the scope and meaning of consent. So the question for us is, what has the new definition done? Has it really changed anything? Or has it just spelled out explicitly in the statute what the courts, especially the Supreme Court, has laid down in some of its progressive decisions, and it has already established. So has the definition just made that explicit, or does the new definition open up new horizons for rape law adjudication in India? I'm going to be highly optimistic today and argue for the latter, that the new definition is truly radical, and if read closely, carefully, and critically. In other words, if we read it like a feminist, it can refashion our entire understanding of sexual relationality. At the outset, I want to make it clear that the definition of consent, which was proposed by the Verma Committee, and now it is there in Section 375, though differently worded, foregrounds the liberal values of autonomy, control, and rational and free choice in one's sexual intimate relationships. So if you look at the text, of 375 and the explanation, in fact, what I had done was I had prepared a PowerPoint for you, and I put the definition there for everyone to see. But I'm sorry, I'm not using that PPT today because I just felt that this online mode is so alienating in itself. If I use a very powerful PowerPoint, I will feel all the more alienated. So I'm sorry you don't have it in front of your computer screen, but I'll quickly read it out for you. The definition reads thus. Consent means an unequivocal voluntary agreement when the woman, by words, gestures, or any form of verbal or non-verbal communication, communicates willingness to participate in the specific sexual act, provided that a woman who does not physically resist to the act of penetration shall not, by the reason only of that fact, be regarded as consenting to the sexual activity. This is what the definition says. So let's open it up. The proviso makes it clear that submission, lack of protest, or resistance cannot amount to consent. Moreover, the accused cannot argue that he assumed the presence of consent because the complainant was silent. Because consent has to be clear, it has to be unambiguous, it has to be communicated. And this communication actually is one of willingness to participate in this specific sexual act. So consent has to be for all sexual acts. Consent for one sexual act cannot lead to a presumption of consent for any other sexual act. Without the woman's communication of willingness to participate, the unequivocal voluntary agreement, which constitutes consent between sexual parties, cannot be effected. This is what is the law now. So I think it's important for us to flesh out these constitutive ingredients in order to discern their implications as well as radical potential for contemporary feminist politics. And I'll come to that. But before that, let's turn to Delhi High Court's notorious decision in Mahmood Falukhi case. The Delhi High Court, in its endorsement of the misogynistic and, if I may add, sexist idea that no may mean a yes, has repudiated the categorical terms of consent introduced in 2013. And the court actually took us back to the no means yes notion, leaving us with the same old stereotypes which we have been fighting for so long. Stereotypes of an ideal rape victim, real rape, real resistance, true consent, and so on and so forth. In fact, I must add that Falukhi is an exemplary case which proves the thesis of British feminist and psychoanalyst Juliet Mitchell, who said that feminism is the longest revolution. Longest because of the silent undertow that always stays with us. Undertow is an expression that she uses, undertow, quite an interesting expression she uses to explain the underlying forces beneath progressive attempts of reform that keep pulling us backwards. It's basically like saying there's something hidden that takes us 10 steps backwards every time we take a step forward. And Falukhi did something like that. Despite the clear and categorical definition, Falukhi reinstituted the man as the subject of law and male reason as law's objective truth. At the heart of the court's reasoning, and I'm sure you all have read it, and you must have noticed that at the heart of the court's reasoning was not what the woman said, but what the man understood. The judge, Justice Ashutosh Kumar, said, and if I may quote him, he said, even if the act was not with her consent, she actually communicated something which was taken as consent by the appellant, end of quote. So the decision thus marked a complete erasure of the woman's voice, her subjective experience in matters concerning her sexuality. Even the specific questions that were raised by the court were framed exclusively from the point of view of the man. And I would just read out a few quotes again from the judgment to substantiate what I have said. For instance, the court said, look at the framing of the issues and the questions by the court. These are the important questions for the court. Whether the appellant mistakenly accepted the moves of the prosecutrix as consent, whether the feelings of the prosecutrix could be effectively communicated to the appellant, and whether mistaking all this for consent by the appellant is genuine. Further, the court insisted, and again, this is a quote from the case, the court says, the unwillingness of the prosecutrix was only in her own mind and heart, but she communicated something different to the appellant. They go on to say, it is not unknown that during sexual acts, one of the partners may be little less willing, or it can be said unwilling. But when there is an assumed consent, it matters not if one of the partners to the act is a bit hesitant. Such feeble hesitation can never be understood as a positive negation of any advances by the other partner, end of quote. So please notice what's happening here. In creating the category of assumed consent, the verdict reinscribed male subjectivity in the domain of sexual consent. It reinforced male privilege to assume consent based on dominant perceptions of the woman's behavior and her reactions. Are such assumptions about consent nothing but a reckless disregard of the woman's subjectivity? Unitedly asked outraged feminists in response to the judgment. There's a lot of literature that came out as a critique of this case, and I think that's really, really worth looking at, worth visiting. The court, in describing sexual interactions as what they call acts of passion, actuated by libido, placed a disproportionate burden on women, and in this case, particularly intellectually and academically proficient women. And what's the burden? That they need to be loud, not feeble. They need to be assertive, not hesitant, and display real resistance, not feeble disinclination. Yeah. Kajal, am I audible?
Yes, ma'am.
Yeah,
yes.
Yeah. Okay. Yeah. I just thought there's some kind of a glitch. Okay.
Please turn off your microphone, Miss Anu. Ma'am, you may go ahead. Thank you.
Yeah. Thank you, Kajal. Yeah. So what I was saying was that, a disproportionate kind of a burden is placed on the woman to act in a certain way, to react in a certain way. So, she has to actually mold her behavior. And a particular class of women are required to do that. But it's never really asked why and how the man is left to make assumptions. How is he left to assume consent? How is he left to actually believe that, yes, the woman is consenting? Why is he never required to be certain, clear, unsure about his belief and understanding of the woman's verbal and non-verbal communications. Why is the man not expected to ask, understand, hear, and not assume, and respect consent? With these questions, I move to the second part, which is where I want to think about, I want to like share some ideas with you on basically reconceptualizing consent beyond liberal individualism as well as structural critiques. And basically actually in doing so push towards a more grounded, more nuanced and more complex theory of sexual desire, of sexual subjectivity, of sexuality and subjectivity. But before that, let's look at the constitutive elements of what the new definition has put before us. The definition of consent now is about an agreement which must be communicated. And in saying so, I would like to argue that the new definition recognizes relationality and mutuality in sexual context or in sexual contacts. Within this understanding, the burden of reaching the unequivocal voluntary agreement is to be shared equally by the sexual partners. At least this is how I would want to read the new definition. And I will actually substantiate this reading by the following. The 2013 amendments, if we note, besides this explicit definition, they have also radically transformed the entire provision of rape. But they've also introduced a fresh clause, seventhly, in section 375. And I would urge you people to pay a little attention to that clause, seventhly, which states that a man would be said to have committed rape if the woman is unable to communicate consent. Now, and I've been sharing this with my students for a long time, and this is a good chance to actually put it out in front of you as well. Now, how do we actually interpret inability, the expression unable to communicate? How do we actually interpret? How do we flesh it out? Is worth thinking about. Narrowly construed, this would only refer to situations when one is not able to communicate due to some physical or mental infirmity. Okay, that is what empathy talks about. However, if we construe the inability more broadly, if we try to understand it in a broad way, this can include situations where women could not communicate. She was not able to communicate because she was not given the space to communicate. Now, what do I mean by the space to communicate? What I mean basically is that the inquiry here ought to be about questions like this. Was the woman really treated as a sexual agent? Was there mutuality and respect in the sexual interaction? Or was the act only governed by male desire and man's beliefs about women's desire? These are the questions that become important if we actually broadly interpret seventhly in this fashion, that sometimes people are not able to communicate what they're feeling, what they're feeling in a particular moment, because they're not given the space to communicate, they're not given the time to think about it, to reflect on it. And therefore, one has to really ask questions about in the interaction in that moment. This reading of the clause, I believe, strengthens the definition of consent, because if we read it with the requirement of unequivocal voluntary agreement, it mandates that sexual acts are not performed in callous disregard of the woman's desire. In other words, it would require that in sexual interactions, the woman is assured the space and time of forming and communicating consent for specific sexual acts. Now, see, it is so this is one thing, if we read the definition together with seventhly. But more broadly, another point that I want to stress upon here is that it is important to approach the issue of consent in relational terms from the perspective of both the woman and man. Because this reading is not only in line with the scheme of the penal code now, but it is crucial for feminist politics. Because this kind of relational view of consent, on the one hand, will view the sexual encounter from the perspective of both the parties, okay, and thus ensuring that man's subjectivity is not solely determinative of the terms of consent, as was done in Falukhi case. But at the same time, it is this relational view would enable us to rethink sexual consent beyond the confines of liberal individualism. And I will return to this point. It's a little turgid point. I understand. So I'll return to this in a while. But before that, let's continue to keep our focus on the expressions that are used in the definition of consent. So, but till now, what am I saying? I'm saying this, that one thing is clear, that the definition of consent aims to make woman the subject of law, but the scope of its interpretation will depend on the interpretive practices and also how individual agency and desire are conceived in interpersonal relationships of a sexual nature. For instance, one may ask, how do we understand the word voluntary? And what kind of understanding of agency informs our notion of voluntariness? An action, so this is what the crucial point basically is, that that we need to basically start unpacking these expressions that we are till now taking for granted. For instance, when we talk about an action or a decision, generally it is considered voluntary if it is free from coercion and undue inducement, and it is based on free exercise of choice. This is the liberal understanding, which is premised on individualistic choice and sexual autonomy, right? This is the broad liberal understanding, which constructs the feminist subject or the legal subject as someone who freely exercises her freedom to choose, decide, and act despite the contingencies and constraints posed by circumstances. Okay, so abstract liberal individuals tells us that you're a free autonomous being. You can exercise free choice. You by virtue of being independent. Okay, and this individualistic choice framework actually assures and guarantees you sexual autonomy. Okay, so in this liberal understanding, your context, your background, your economic situation does not have a real bearing on your capacity to choose. Those questions are really immaterial, right? This notion, this abstract legal individualism and the notion of free choice within it, we know is fraught with difficulties, precisely because it actually negates the importance of these other economic, cultural, social factors which actually go on to construct our choices. As Nicola Lacey, who's a feminist criminal law commentator, she has warned that in an individualized notion of consent and sexual autonomy, which the liberal model gives us, there is a false assumption that the mind remains in control, that our choices are meaningfully chosen irrespective of material circumstances. Okay, so we really know now that the liberal understanding of consent is deeply fraught with these kind of problems. The question thus is, if we have to move away from abstract individualism of the liberal kind, what do we do? Should consent then take into account not only the absence of visible and tangible physical force, and should it be given an expansive meaning where an action can only be called free and voluntary only if there are no other economic, material, or emotional constraints. When passive submission is not out of fear of accused's physical power, but also fear of material deprivation or emotional abandonment or emotional concern. So should we take these factors into account while understanding consent or the presence or absence of consent? The dominant feminist position and the dominant feminist position, which actually views, which is premised on this belief that men dominate women and the tool of domination is sexuality. Okay, so all women are dominated by men, and the nature of the domination is sexual domination. Okay, this is very broadly put, this is the dominant feminist position. That position would see all these scenarios that I was talking about, material deprivation, emotional abandonment, emotional concern, as situations which would make the sexual encounter non-consensual. Okay, because according to dominant feminists, the exercise of female sexuality is not about choice, but compromise for survival. As Catherine McKinnon, who's one of the pioneers of this position, says, that when dominance is eroticized, then even when a woman is saying yes, it does not reflect her consent. Okay, so dominance position actually is a huge 180-degree turn to the no means yes, framework which we saw was adopted by Falukhi. So because dominant feminists would say, all yes means no. Because women would say yes only because there is some kind of pressure operating because of either economic or financial dependence, or because of cultural or social factors and so on. Some would view this would actually say that this is a compelling view. But the problem the big problem with this position is that dominant feminism imposes a static identity of victimhood on all women. And therefore, it ends up closing all possibilities of imagining sexual freedom and agency for women. And that's the reason why it has come under huge critique from post-colonial feminists, for example, or feminists who actually adopted deconstructive practices in looking at sexual power and so on and so forth. And here I would want to take you to the work of Vanessa Munro, who questioned not just the liberal conception of consent, which I earlier talked about, but also the dominant feminist position, and pushes towards what she calls a consent plus model. Munro, through the consent plus model, insists that there should be a procedural insistence, and these are her words, procedural insistence on critical reflection about the reasons that underpin, constrain, construct, and motivate our choices. So what is she doing? By giving this framework, basically she's suggesting that the willingness to participate in the sexual act should not just be assessed from the standpoint of abstract individualism and liberal notions of agency and free choice. Instead, willingness needs to be discerned by examining the concrete context in which that choice was framed, selected, and then acted upon. Munro's argument basically is that the agreement to have sex is free only when material and cultural constraints are duly evaluated. So you cannot really consent freely if there are material and cultural constraints that are operating, in your decision making, right? So basically, she's actually making this point that we really cannot disassociate material and cultural constraints, the impositions that play a huge role in our day-to-day interactions, while understanding how our choices are constructed. Instead, we have to look at our choices and the decisions that we have made, keeping in mind our background, are the constraints that actually work upon us and actually constitute our subjectivity. The idea basically is to entrench concrete consent into long-term relationships, and because these relationships can be permeated with more subtle and hidden forms of domination. The idea again is not to uncritically accept all constraints as erasing agency. Okay, it's not to say that the woman cannot consent at all, or for instance, it's not to say that in and see, because these kind of stereotypes also are extremely dangerous, and they can and they do operate in this discourse that a woman in the third world perhaps is not a sexual agent, right? And these kind of stereotypes have been put to a very, very strong critique by scholars like Ratna Kapoor, who have talked about sexual subalterns and so on and so forth. I really don't want to go there. But the point that I'm trying to make here is that, and this is Vanessa Munro's point, that the question is not to accept all constraints as constraints which would erase sexual agency and sexual choice, but putting your choices and putting your agency and your decisions to critical reflection, to critical evaluation. For example, asking whether the woman was saying yes to sex because of financial dependency, social pressures, and so on and so forth, which may be hidden, which may not be really, really apparent. And the Me Too movement across the world brought forth, for instance, the professional constraints that determined women's sexual choices. So, and this was all latent, this was all hidden. So Munro is basically saying that we really need to actually push law in the direction where we take into account, we start paying attention to these subtle and hidden forms of domination. No doubt that there are difficulties in integrating this approach in law. For instance, Munro says that we would really be struggling to figure out the kind of evidence that will be required to assess the legitimacy of a person's preferences, individual preferences. Further, she asks that would this lead to law's excessive intervention in personal life and your personal choices and your encounters with sexual encounters? And would this not put the accused at a disadvantage, because the accused would be required to ensure that the woman's consent that he secured was not tainted with self-alienation, and it was, and there were not subtle and psychic constraints that were operating. Okay, so these are important questions, that, and difficult questions if we are to integrate Munro's approach in law. But despite these difficulties, she argues for an integration of this approach within law, at least with respect to the actus reus of the crime. She writes, and just the actus reus of the crime, by the way. Okay, so she writes, and I quote, and I'll read this slowly for you so that you know what she's talking about. She says, this re-engagement with the consent threshold affords an opportunity for the law to lead by example, holding out a model of sexual relations that takes both mutuality and reciprocity seriously, and thereby generating attitudinal changes that may in time permit holding defendants to a higher degree of accountability in regard to their sexual communication strategies. In addition, the extent to which this approach puts the experiential perspective of the complainant center stage, at least in its evaluation of the actus reus component of the offense, is itself symbolically important, since this perspective has too often been neglected, distorted, or rejected in the rape context by both legal and feminist analysis. End of quote. So her idea is that this kind of understanding of sexual consent, and if this idea is incorporated in our understanding of active spheres, it is going to generate attitudinal changes. It's going to hold defendants to a higher level of accountability. We have to be, and where individuals are made accountable with regard to their sexual communication strategies, and it's going to foreground the experiential perspective of the complainants. So in other words, what she's arguing for is foregrounded women's subjective psychic states, which are determined by hidden material constraints. So this is what she suggests. Now, I want to push the argument a little further, because there's another issue that pertains to the complex nature of sexual desire. And here I would want to turn to the psychoanalytic understanding of sexuality and sexual desire, which far exceeds the contractual terms of sexual consent in the juridical model. So the question basically is that, can we really apply the contractual model to sexual desire? Is sexual desire, can we actually fit it within the frame of the agreement as the law of contract, as dominantly understood, conceives agreement to be? Here I would want to take you to an essay by Judith Butler on consent law and psychoanalysis, where Butler has argued that the juridical model of the volitional individual implicitly operates within certain norms governing individual autonomy, and therefore there is a need to rethink consent in relation to another set of terms that cannot be fully constrained with this kind of legal language and its presumptive individualism. So yes, she is, very simply put, she is making she's making a critique of individualism. She's making a critique of understanding sexual consent and trying to fit it within the juridical model of agreement and contract. But beyond that, by introducing psychoanalysis, what Butler is attempting to do, and I think that's extremely interesting and very, very important if we really have to radically understand the sexual consent in not just rape law, but even otherwise in other in various other legal provisions. What the psychoanalytic understanding brings to the fore is the complex and uncanny nature of sexual desire. And here I would want to quote from this essay where Butler asserts, and I quote, "Although consent is supposed to be active and clear-headed, sexual consent can involve much less active terms: being moved, being curious, finding oneself open to what is unknown, impressionable, vulnerable, surprised, intrigued, or even moved along and drifting, wondering what will arrive, relinquishing, ceding." End of quote. Okay, so she's basically saying that it is difficult to actually fix it and fit it within a frame that appeals to and that is comprehensible to the juridical mind. Because it is more, and look, see the kind of words that she has used. It is an impressionable, it is unknown, it is full of surprise and intrigue, it drifts, right? Obviously, this is not to suggest any dilution of the feminist standard of consent, but to recognize the complexity in charting out sexual consent in strictly contractual terms. This is the point, it's definitely not to say that, really in terms, when it comes to sexuality, we really don't know what's going on. It's not that kind of a point that she's making. The point instead is that sexual interplay often does not conform to the laws of language, but to acknowledge the delicate balance between what is said and what is not said in sexual interplay. Right? Again, I want to emphasize that this is not to suggest, like Falukhi does, that no may mean a yes. But it basically, if you really have to, make something for these kind of popular understandings, what we really need to do is, these kinds of notions of assumed consent, etc., they need to be turned around in the service of feminism for a thick description of consent and sexual desire. This is what this is what I mean by a more grounded and more complex understanding of sexuality and sexual desire when it comes to consent. Moreover, a complex psychoanalytic understanding of sexuality, which acknowledges how closely intertwined sexuality is with violence, will liberate us from the seduction of dominance feminist position. For instance, the dominance feminist position assumes that all men, okay, and all men, and especially older professional men with higher degrees, earnings, and experience, all of them will invariably have more power than women, especially younger women, women with less experience, less earnings, lesser degrees, etc., right? This is what the assumption in dominance feminist position is. While this may be a valid assumption in the wake of patriarchal structure and entrenched sexism of our culture, especially, and also of public places where men act with a sense of entitlement, it is pertinent to ask whether this assumption can be extended to all sexual relationships between such subjects. And I think I would want to say that perhaps it is time that we question the very premise of the impossibility of consent in situations of power asymmetries and ask if agency, autonomy, and desire are always already eternally structurally constrained by differences in position, background, sex, age, etc. Are they already determined? And if yes, wouldn't this view of consent, and what am I, this kind of view of consent, and what is that view? That consent is already determined fully and exhaustively by structural constraints. Okay, wouldn't this view take us back to the imagination of women as helpless beings who are waiting to be saved by paternalistic laws of the paternalistic state? Right, so basically what I'm saying is we really need a more nuanced account of sexual power, which cannot be informed by the simplistic understanding of power which dominance feminist position relies on. Moreover, when an adult woman says yes, for example, in situations where when one can be taken over by the erotics of male power, or knowledge in workplaces, educational institutions, etc., can this consent automatically be designated as involuntary on account of, again, power imbalance? Okay, so this is not the question that was actually thrown at our face in the Me Too movement, in the hashtag Losha movement, and this question has stayed with us. That how do we actually situate? How do we actually understand the consent of adult women who, adult women who may not be in positions of power, in workplaces, educational institutions, etc., etc. In this regard, I would really recommend you to read and look at the work of Laura Kipnis, who, in her exploration of the implementation of sexual harassment policies in US universities, argues, and I quote, that youth and attractiveness may also offset the weight of institutional standing and higher degrees. So do calculations about who's more likely to end things first, end of quote. Now, important observations, I must say, because denying this would constrict women into a kind of sentimentality into female vulnerability, that all women are vulnerable, okay, and they're perpetually vulnerable. They will continue to be vulnerable. And this is going to be a very, very problematic position, again, because all possibilities of true consent then would be predetermined for women, denying them the freedom to make their own sexual choices, including the choice to make wrong choices and the choice to commit mistakes. So basically, if I can just sum up what I've said till now, is that in our conceptualization of consent, we cannot be weighed down by either the abstract individualist paradigm or structural critiques which have taken the form of dominance feminism. We need to go beyond this binary and ask difficult questions about power, sexual power imbalance, as well as take into account psychoanalytic understanding of sexuality and consent, which cannot be understood through fixed and deterministic frames of either law or even feminist, even feminist visions, which are tilting towards the dominance feminist frame. So, I must say that, if this has been a little, because as I'm speaking it, I'm beginning to feel that there are a lot of ideas in there, and I'll be very, very happy to engage with every question and, maybe re-clarify what I've said in the Q&A, to make the points that I have attempted to make in whatever I've said till now. But with that, I want to go to the final part of my talk today, which pertains to the question of mens rea. And I think it is important for us to spend some time on this question, because, and not just because it is a technical legal question, and in itself that gives us enough reasons to actually engage with it, but also because this question has serious implications for feminists, as it is intrinsically enmeshed with the issue of consent. On the question of mens rea, criminal law scholars, as far as the Indian Penal Code is concerned, have conflicting and contradictory views. Barry Wright, for instance, notes that the rape provision is silent on the question of whether the accused has to know the victim has not consented. And he calls it a curious omission in light of Macaulay's emphasis on subjective liability, by which Barry Wright means that IPC is primarily subjectivist, right, as far as criminal liability is concerned. For example, it rejects the felony murder rule, it rejects thin skull principle, it focuses heavily on intentional knowledge, foresight, and so on. These are central subjective states in IPC. So, and that is why the absence of the fault element in section 375 is characterized by Barry Wright as a curious omission on Macaulay's part. Right? Now, this curious omission has been read very differently by legal scholars. Some have argued that the absence of an explicit mens rea makes rape a strict liability offense, while others resist from such a reading in light of Macaulay's broader philosophical orientation towards liberal individualism. He would not read, and they say that Macaulay would not want to read section 375 in this way. He could not have conceived it to be a strict liability provision or a no mens rea position. Strict liability is an anachronistic phrase as far as Macaulay is concerned. So anyway, so basically there are two positions. One camp says that section 375 is a no mens rea provision, and there are others who say that we have to actually, we will have to read mens rea into section 375 because it's, it's not excluded by necessary implication, right? So these are the two camps. Wright, for instance, does not read rape as a strict liability offense where the accused's belief about victim's consent would not matter at all, okay? And because he says that despite the silence on the question of knowledge about consent in rape, Macaulay's otherwise careful consideration of consent and other provisions were informed by individualistic liberalism, where individual autonomy is placed ahead of competing interests, right? So basically, Wright is saying that by necessary implication, that the statute would require that we read mens rea into it, even though it is silent on this question. So, but if you actually look at other commentators, for example, Stanley Yo, who has written extensively on the Indian Penal Code, he would say that conceded that mens rea is certainly not an offense element of rape, but that does not preclude from an inquiry into the state of mind of the accused. Yo points out that the legal burden rests with the accused to prove on a balance of probabilities that he reasonably believed that the woman had consented to having sexual intercourse with him. Hence, according to Stanley Yo, even if we look at rape as a strict liability offense, it will still continue to be governed by Chapter 4 of the IPC, and the accused would be entitled to rely on general defenses. Similar position is taken by Kumaralingam Amithalingam, and who's categorical that Section 79, which is about mistake, can be applied to strict liability offenses and can definitely be applied to Section 375. In contrast, if we look at the position of Mrinal Satish, he has argued for a long time that rape is a no mens rea offense, and this precludes the defendant from pleading the defense of mistake. Okay, so it is that kind of strict liability offense where the accused cannot even plead any defense that is otherwise available under Chapter 4. This position, and by which I mean Mrinal Satish's position, can be backed by the reasoning that accused men would always plead honest belief. That they would always say that, oh, I honestly believed that the woman was consenting, and if we see rape cases from common law countries, this has been a subject of concern, that accused men have always come up with this kind of defense. And that is Satish's fear, where he says that rape cultures that inform the social and legal understanding of rape would always tilt towards giving the benefit of doubt to the accused if we actually allow him to plead the defense of mistake. We must concede that this position is in tune with a strand of feminist scholarship, which shows that even if there is a shift from honest belief to reasonable belief while determining mens rea, one may not automatically get feminist results, right? Because even reasonable belief can be construed in a very, very through misogynistic standards, in patriarchal cultures, right? So because of this, they would say that strictly construe rape to be a no mens rea offense, call it a strict liability offense, and deny any possible defense, including defense of mistake, of fact, right? So these are the diverging views as far as the question of mens rea or the question of strict liability as far as rape law is concerned. However, I'm going to challenge this strict no mens rea view, which is taken by scholars like Professor Satish on feminist grounds, and instead argue that the very idea of mutual consent in sexual relationships requires us to accord space to inquiry into accused's mind. My position is in consonance with the view held by Stanley Yo, who believes that in the context of rape, the accused's claim is essentially one of mistake of fact as to consent and not Section 90. And he says, Stanley Yo rightly, in my view, says that Section 90 would not be applicable because the provision of rape does not have a fault element in it. Okay, so the correct defense that one has to rely on is Section 79, right? So, and since according to IPC, Section 79, mistake of fact must be in good faith, that is with due care and attention. The mistake is not purely subjective to the accused. The accused cannot just plead honest mistake. That mistake has to be reasonable mistake. Okay, this is how I read the Indian Penal Code. And in doing so, and I think this reading is important, and this reading I think is the correct reading, and I follow Stanley Yo in that regard, because excluding inquiry into accused state of mind and exclusively focusing on the consent elements solely from the perspective of the woman would align with the objectives of carceral criminal law project that is repressive as well as sex negative. While it may appear to be in the interest of women, that by excluding by strictly making it a strict liability offense, it might appear that we are actually giving some kind of real space to women's word, experience, feelings as against the man. The danger is that this kind of interpretation can freeze the norms of female weakness and male power, women's vulnerability, and man's dominance. And it may foster a culture of dangerous social control by punishing those who honestly as well as reasonably believed that they were having consensual sex. While there is no doubt in my mind that the norm of reasonability in reasonable mistake has to be robustly debated, and it must conform to feminist standards, completely doing away with the reasonability standard in order to protect women. Let me just take a minute here to explain this. What I'm saying is that we have to hold on to the norm of reasonability. However, reasonability has to be, it has to be subjected to the feminist framework, and it is important. And why is it important for us to hold on to reasonability? Because doing away with it would amount to abandonment of the site of reason and debate, with the possible danger of characterizing women as beings who are incapable of rational communications. Rational communication that can be objectively understood and reasonably accepted. That would be really, really dangerous, because we will end up slipping back into the age-old stereotyping of women as devoid of reason, objectivity, and competence, of debating the value structures that determine sexual interactions, and the value structures that constitute our public spaces. So I think we really need to have a discourse around reasonability, and we require more feminist and progressive voices, in those debates, so that a feminist standard of reasonability is upheld when we are talking about reasonable mistakes. Now, if I may return to Falukhi again, Falukhi had said that the woman actually communicated something which was taken as consent by the appellant. What I'm saying is, yes, let's take Falukhi seriously, but the only thing that we need to do is that we need to ask the court, what is that something? And we have to ensure that and see whether the court is evaluating that something from the standard of feminist reasonability. This is what is really required if we have to radically create a shift in the discourse as far as sexual interactions and sexual consent is concerned. With that, I would want to just conclude. I don't know how much time I've taken, Kajal. I think it's too late, to really ask for more time. But I'll quickly conclude by saying that criminal law is as much about bringing a change in how one wills as it is about imposing criminal liability. And therefore, it is imperative to keep the dialogue between the two sexes open, not just two sexes, all sexes open, if we are to achieve the feminist objective of reshaping sexuality through values of mutual respect, dignity, and understanding. Then it is really not desirable to exclude men from the conversation by slipping into dominance feminist strands and reading the penal code in a very, very strict and confined way. Indeed, if the goal of legal education is what Gayatri Spivak in a different context has called uncoercive rearrangement of desires, then we need to raise difficult conceptual questions around consent and strive to engage with nuanced accounts of sexual and desiring subjects. To this end, in addition to the feminist values of bodily integrity, mutual respect, and communication, we need to take into account the psychic dimension of sexuality as well. And this will be possible by re-inaugurating the feminist subject outside the fantasy of liberal autonomy, as well as the victimhood theses of dominance feminism, and moving towards a grounded understanding of sexuality that captures the complexities of the sexual relationships and the notions of sexual consent. I think with that, I would end. Thank you so much for your patience, and I would be very happy to take any questions or maybe listen to you take comments.
Thank you, Dr. Vashisht, for such an insightful lecture. It was intriguing and thought-provoking. And I would like to request Anumeha Mishra ma'am, Assistant Professor of Campus Law, to please take the floor and moderate the question and answer session.
Thank you so much, Kajal. And thank you so much, Kajal. And also thank you so much, Latika, for really bringing so many points on consent with regard to 375 before us, because and also making us question the idea of consent per se, which is something that we rarely do in our readings of the penal provisions. There are a few questions, and I would take this opportunity to maybe pose those questions before you. The first question is by Pallav Grover, and the question he's making is that it might so happen that any person involved in a sexual act might have acted with a decision taken in a nick of time, where one factor of many others, while assessing the option and coming to that particular decision of giving consent, overpowers other factors. So while deciding a case, how can we give weightage to the evaluation component of options available for giving consent?
Okay, so Anumeha, can I again read the question? The question is in front of me.
Sure. If you could take this question.
Yeah. I'll decide. Okay. Thank you for this question, Pallav. So basically, you are saying, and I look at this question. I think this question came in the context of the discussion discussion around the consent plus model of which is proposed by Vanessa Munro. See, what she's basically suggesting and when we say that we have to look at multiple factors, the point is that we really are. It is important for us to go back to the basic and the most fundamental point which is about how do we understand choice making. Like you're saying here that there may be various factors involved while taking a decision. as far as sexual consent is concerned. And that's true, always as far as any human interactions, including sexual interactions, are concerned. There are multiple options that play upon people's mind when they arrive at a particular decision. So the question before the law should be that all those factors, or at least the factors which are available before in the that have come before the court through evidence, they are evaluated critically rather than negating them and only premising the decisions and legal conclusions based on what you have called decisions taken in the nick of time. I really wonder whether decisions are ever taken in the nick of time. This kind of understanding of sexuality is a very, very limited understanding that, and it is. This is what Falukhi also tried to say, that, they are actuated by libido, and you really don't know what's going on. I think this is what we really need to move away from. We really need to understand sexuality as a zone where other material factors also have a crucial role to play in when it comes to the decisions of our sexual relationships and our sexual partners.
Thank you, Latika. Now, the second question is basically with regard to post-incident consent, and can a post-incident consent, is it in conformity with the progressive view related to value and principles of consent?
Not at all. Not at all. I think this is this question, which is about Allahabad High Court quashing a rape case.
Yes. If you're comfortable, maybe you can read the questions and answer it. It's more comfortable to you.
Yeah. So the question is that the Allahabad High Court quashed a rape case after the survivor and accused reached a settlement. What were the terms of such settlements, one may ask, right? What is the? I mean, and that's the important point, that when we say that are both the parties on the same, is there no power imbalance between the parties? How are such settlements reached? And I think Pratiksha Baksh's book, Public Secrets of Law, has a chapter devoted exactly on this point. And I think we really need to look at that chapter which is about compromise in rape cases and so on and so forth. So I don't think that this kind of post-incident consent makes sense at all. How far is this accepted by a progressive view related to the value and principles? It's I would say it's a totally regressive view. It has nothing progressive about it at all. It is. But yeah. Let's. If I actually try to read this question in this way, that if you're saying that perhaps the woman wants to settle the case with the accused, right? The survivor wants to. If I read the question like this, then how would we actually? Then would we say this is progressive or feminist? My personal view is that no, we cannot accept, as far as law is concerned, these kind of settlements, cannot be accepted. They cannot be a part of law. But there is some writing around agency. If you look at, for example, there's an essay by Rajeshwari Sundarajan. It's called "Life After Rape," which talks about questions of agency post-rape. The decisions that are made by women, whether a woman wants to file a complaint and so on and so forth. But if, in my personal view, this can never be a progressive view. These kind of post-incident. They're really going to backfire the feminist understanding as far as sexual consent is concerned.
The next question seems to be by Aarti Bansival, where she's asking you to quote examples of non-voluntary consent in marital relationship or consent in adopting prostitution due to financial needs.
Please, for examples, as in or consent in adopting person. Anumeha, I'm not able to understand. What is the question?
I think, if I'm correct, she wants to ask that even, for example, prostitution many times, or in prostitution also, there is an argument made that it's there is a consent in prostitution, but perhaps with regard to the dominant position, or the dominant feminist position, it may be argued that because there is no agency per se vested in the woman, even if she's giving consent, there is no consent at all. So I think maybe it's in that context that Aarti seems to be asking question that that in such situations specifically which appear to be non-consensual, for example, within the confines of marriage or prostitution per se, can we still argue for agency, or can it be still argued that there is a consent that has been given by the woman?
Yeah, see, as far as sex work is concerned, yes, you're right, Aarti, in pointing out that the dominant feminist view is that, that all sex work is non-voluntary, and this position has been seriously critiqued by a lot of feminist scholars who've worked very closely with sex workers, including people like Prabha Koteswaran, Ratna Kapoor. Ratna Kapoor specifically talks about the category of sexual subalterns, and to basically understand, to basically make the argument that they should not just be perceived as victims. Right, they are agents, and that's why this expression sex work, that people can be choosing to do what they are doing. Again, all choices are constrained choices, and in all choices, not just sex workers' choices, even our choices are constrained choices, right? So, in agency in that context has to be understood in alongside constraints, but this kind of view that there is no consent as far as sex work is concerned, would be a very, very problematic view to take. I don't know what you mean by non-voluntary consent in marital relationships. Yes, like, if you're trying to make the point that whether marriage means that consent for all time has been given, absolutely not, right? So even marital relationships have to be treated in the same way as other sexual relationships are treated as far as consent is concerned. Marriage is no excuse, it is not, it cannot be treated as a privileged institution as far as bodily autonomy is concerned.
Yeah. Thank you, Latika. So the next question is by Sabrish Suresh. And the question that is being posed is that the definition mentions that consent can be given through any, I think the definition in section 375 mentions that consent can be given through any form of verbal or non-verbal communication in addition to words and gestures. He wonders what the legislation means by this, and what are the verbal modes and non-verbal modes through which consent can be given. And how does law assess these verbal and non-verbal modes as unequivocal consent?
How would the law assess that such verbal and unequivocal? Does this addition textually undercut the unequivocal requirement? Yeah, thank you for this question, Sabrish. It's a very, very interesting question, because in a way you are saying that the way the definition is couched, it is couched in contractual terms, right? I mean, it is talking about agreements made through these ways. So how can, and if it is couched in contractual terms, how would we ever really know whether there was presence of sexual consent or not? I would say I agree with you, but I think this is what we have, and it is important for us to flesh it out in a way where these expressions are understood in an unconventional manner, right? So, for instance, like, I'll come to the specifics of what you're asking, but agreement can be understood in the way it is it is taught in a contract law class, or it is, where both the subjects are fixed in time and space. But it can also be, agreement can also be understood in a way where we actually have different notion of temporality and space governing agreement between parties, right? So, I mean, where change is a part of agreement, is not fixed in time. People, the parties, the subjects are not fixed in time and space, right? So there's also a possibility of basically giving different meaning to the expressions that are used in this definition. Now, but the first point that you made is quite interesting, that what are the verbal modes which are not words, right? Again, I think you are reading it psychoanalytically already, because I would say that yes, all verbal modes, because language does not exhaust the space of sexuality, right? Sometimes language cannot even capture the modes of sexual interplay. So I think it is for us to actually, take these expressions and give them a meaning which is not really constrained by contractual juridical terms of the legal space. Yeah.
The next question is from Maham Siddiqui, and the question is that what Mundu's concept of consent plus means correctly to say that consent requires an absence of material or societal constraint. Wouldn't such an understanding of consent automatically be detrimental to the legalization of prostitution, considering the fact that under prostitution, consent might generally be due to financial or material considerations?
Yeah, so that's what I'm saying, not necessarily. I think Aarti's question was similar, yeah. Right? So, not necessarily, it may not just be due to financial or material consideration. And I think, why do we single out prostitution or sex work as a profession when we have to raise this point? I think all our decisions, most of our decisions, what we choose to do or not do, is governed by a lot of material consideration, including financial constraints. So I don't think we can just single out the issue of prostitution here.
So before I move on to the next question, maybe I'll pose a follow-up question. So would it be safe to say that instead of searching for an absolutely free consent, what we are searching for is a form of consent that meets the feminist standards? Because I don't think it is possible in this world to have a consent which is completely free of all considerations. So it is more with regard to how far we can conform to the feminist standards of consent that we are looking for in sexual offences law.
Yeah, yes, absolutely.
Yeah. There's a next question by Karthik Dora. That according to Mundu's consent plus model, is it just a general affirmative signal that there is consent, or there should be an unambiguous and unequivocal consent? With respect to second explanation to section 375, though they mention unequivocal voluntary agreement, but when it comes to form through which it is expressed, one can be unequivocal and unambiguous only if it is a verbal yes, whereas the definition includes gestures and non-verbal communication, which according to me defeats the purpose of consent if you take it to the highest possible standard. What would you say with respect to definition in the IPC?
Firstly, there is a difference between consent plus model and affirmative consent. Consent plus model, in the consent plus model, Munro is only saying this, that we really need to take into account material, economic, and cultural constraints while assessing the presence or absence or consent, right? So this is the only thing that she's saying. I mean, it is not about being unambiguous and unequivocal, because I don't because this is, I mean, as far as her model is concerned, it is, she's not using this kind of language. In fact, these words are taken from another model, which is about affirmative consent, where the accused is required to take specific steps to figure out whether the woman is consenting or not, right? So I mean, that is a distinction that we need to make. As far as your second question is concerned, that whereas the definition includes gestures and non-verbal communication, which according to me defeats the purpose of consent if you take it. So I'm wondering if you're saying that that consent can only be expressed verbally. I mean, again, this kind of, I don't know, like this can really be a very narrow view of how we interact, and not just with regard to, with respect to sexual encounters, but even otherwise, right? I mean, we are really placing a very, very high sort of a premium on language, right? I mean, and I think the whole point is that, and in the context of sexuality and sexual interplay, that there's that we have to actually we have to take into account that expressions and communication can exist outside language. It can, one can actually express desire, express affection, love, even in the absence of expressed words. So I don't really see why it would defeat the purpose of consent if we talk about gestures and non-verbal communication.
There is a similar question by two individuals, Akash Dikshit and Manish Mishra, and they would like you to comment on the fake rape allegations which are made by certain individuals.
What do we mean? How are they defining fake rape? Like, what is the meaning of fake rape?
I think they are making a case for those rape allegations which are where individuals are falsely accused of raping a woman. So I think they are referring to those allegations.
Mm-hmm. This is Akash Dikshit's question. Can I?
Yes, Akash Dikshit.
Yeah, okay, I'll just read it. What are your views on? Okay, they don't marry. Okay. These are promise to marry cases.
Yes.
More willing to have this. See, if this question, if you're asking the question about promise to marry cases, and I think it's a very very important question, because in a study it was pointed out that promise to marry cases account for almost 70% of all rape cases which are filed in Delhi. What is my view on that? I think the category of promise to marry, firstly, I think that promise to marry cases are not rape. Breach of promise to marry, according to me, would not amount to rape. So this is my position, and this is the position of the Supreme Court as well. However, I would urge you to look at the work which is undertaken by Majlis and the writings of Flavia Agnes, who really pointed out again the material complexity of the promise to marry cases, the position, the class and caste position of the accused vis-a-vis the woman, and so on and so forth. Flavia Agnes, in that regard, argues that they may not be rape cases, so to speak, but these cases are definitely those cases. They're cases of cheating which have to be taken extremely seriously, because often women from lower class and lower caste are lured by men. They are impregnated, and then they are just left with a child and abandoned by the man. So these women need to be supported, definitely not by saying that it is rape, but through other measures. So I guess, but the point is that yes, promise to marry is a very, very important category that needs to be deconstructed, and it cannot be subsumed within rape. Yeah.
Another question by Shivam Kataria, that should a feminist standard of reasonability also come in while interpreting the actus reus? And not from the point of view of the accused reasonable person in his position, but a reasonable third party's position? Or should the standard remain of subjectivity of the particular woman?
Okay, this is a very good question. This is a very good question. Because when we talk about the actus reus of rape, okay, and I have tried to argue through the work of Munro that the requirement of actus reus has to be changed, and it has to conform to what Shivam, you are calling the feminist standard. So the unfortunate part is that even if and Munro recognizes it, that even if actus reus is interpreted through what she has called the consent plus model, okay, so even if actus reus is interpreted in a way where consent is it is operating outside the confines of the liberal model, then also this whole idea can be defeated if the perception about mens rea is such that it is solely governed subjectively from the perspective of the accused. Okay, so basically Munro is saying that all our hard work in moving towards a complicated account of consent from the perspective of women can be undone if we do not have a similar if we actually don't take similar steps as far as mens rea is concerned, because the man can always say that, okay, the woman perhaps was not consented, but I thought that she was consenting. Okay, so basically the point is that the feminist standard has to prevail in our understandings of actus reus as well as mens rea. Okay, so when we push towards reasonability, we have to push towards reasonable understanding, even in our understanding of mens rea. Otherwise, it would, the whole idea is going to fall flat. I don't know, and it seems so weird. I cannot, we really are really talking to each other. I'm talking to the computer, and so are you.
Yes.
I don't know if my answers are even making sense to the people who have posed these questions. So we can continue this, but I would really urge that if anyone wants to get in touch with me, please write to me. I can leave my email ID and my phone number, and I would be really happy to carry on this conversation and maybe on a one-on-one level. I don't know, it just is so difficult to.
I completely understand. All of us are adjusting to this new normal. Yeah. So I think, Latika, if I have time, to just one last question which is there. This is by Dr. Praveen Kumar, and it's a very simple question. He's merely asking that, do you support the definition of consent under Section 375 of IPC?
And if not, what's that point? What? If not, what? I don't know what you mean. What you mean by the second question? See, it's not about supporting the definition of consent in IPC or not. As Sabri Suresh pointed out, and I don't know if I got his question rightly, that one view is this, and I myself used to have this view a few years ago, that the definition of consent in Section 375 now is couched in contractual terms, and that's a problem, right? But now, like today, I've tried to argue that this is what we have, and we really have to read it in ways which are, and we actually have to give it meanings which are which are taken from more complex understandings of sexual lives and sexuality per se and sexual desire, right? So if we do that, I think there's much to rejoice about as far as this definition is concerned, because this definition is one thing that's good about it is that it is trying to ensure that the woman is that she becomes the subject of law. Okay, unfortunately, that was what was undone in Falukhi. So, in that sense, yes, I do support the definition of consent in 375.
Thank you so much, Latika. Thank you so much for that wonderful session and also answering all our questions so patiently.
Yeah, I wonder.
And also, it was wonderful having you here, and we look forward to many more interactions with you. So now I would like to invite Kajal Sonkar, who is the convener of the Debate and Discussion Society, to maybe conclude today's event.
Thank you, Anumeha ma'am, for conducting this session. And ma'am, again, Latika ma'am, I would really like to thank you. And I'm very, I'm sure that each one of us has gained a unique viewpoint today with reference to this topic. Even though that person might be well versed with feminist politics and legal feminist theory, but I'm sure they have gained one or the other viewpoint today. And with this, we come to an end for today's session. And I would like to deliver my vote of thanks on behalf of the Debate and Discussion Society to Professor in charge, Dr. Raman Mittal sir, and teacher convener of Debate and Discussion Society, Dr. Seema Singh ma'am, for their continued support and encouragement. I would also like to extend our heartfelt gratitude to Dr. Sujit Poonan sir and Ms. Anumeha Mishra ma'am for making this event possible. And I would now like to thank everyone for joining us today. Special thanks to all the faculty members who joined us today. You may keep following the DDS on different social media platforms for the updates for upcoming events of the society. Thanks a lot, Latika ma'am, again for joining.
Thank you so much, Kajal. Thank you, Anumeha, for having me. And thank you for all the participants for bearing me. So yeah, hope to meet you soon in person.
Yes, ma'am.
Yeah. Okay.
Thank you. Thank you.